In today's video, we discuss what are the minimum number of times per year that a physician must see a patient in person prior to treating the patient via telehealth. By the end of today's video, you'll have a deeper understanding of telemedicine legal requirements regarding the physician-patient relationship. You'll also separate myth from fact when it comes to having the MD or DO see the patient physically in person prior to further digital, online, or mobile telemedicine, telehealth treatment. I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. Since 1999, our law firm has counseled over 1,000 healthcare industry clients on healthcare and FDA legal issues. Telemedicine is one of our sweet spots. We were early pioneers in telehealth, as telehealth, also known as digital health, e-health, mobile health, connected health, began to catch on. We recognized that telemedicine was the future of medicine as professional relationships moved from physical to digital to virtual space. Along the way, we heard many myths about telemedicine law. For example, what we heard is you're okay so long as you have at least one visit in person a year with the patient. That's a myth. Nobody knows where it started, but somehow it feels very self-soothing to say I'm legal okay as long as ... is the case. And healthcare companies and practices believe the myth because, like the song goes, I heard it from a friend who heard it from a friend who heard it from a friend. We lawyers call that quadruple hearsay. It doesn't matter that one of the friends in the chain was a lawyer. Why don't we just dispel the myth and get right to the law? When the technology began to evolve to allow effective video communication between doctors and patients, states at first were slow to catch up. Many state laws and medical board regulations and policy statements required a face-to-face visit between the doctor and patient. The idea being that these faces had to be in the same room physically at the same time. In fact, the statutes, regulations, policy statements, medical board disciplinary cases, and judicial opinions often said that, for example, telehealth treatment and prescription based on an online questionnaire were not standard of care and were prohibited by law. Sometimes the rules were much stricter for prescribing than diagnosis or treatment. Over time, a patchwork of laws formed across states. Well, then lawmakers and regulators began opening up a more liberal pathway for telehealth. In this new version, they did not require the physical exam and the in-person encounter, but rather they allowed telemedicine provided that the physician first establish the physician-patient relationship. The physician-patient relationship, it could be established in a variety of ways, including not only the in-person good faith exam or clinical encounter, but also by an audio-visual encounter augmented by an effort to ensure that the patient really was who they claimed to be. Among other things, the audio-visual connection had to be sufficiently reliable from a technological perspective. Once this physician-patient relationship was established, the physician then would be subject to certain professional obligations, like informed consent, and liability like malpractice. This is pretty much the current trend. Remember, though, that the telehealth encounter still has to meet the standard of care, and that the technology used has to be sufficient to allow for accurate treatment and diagnosis in accordance with that standard of care. Depending on the state, the community standard, and the type of condition involved, standard of care might or might not require a medical history or physical examination. Standards of care evolve over time. In dermatology, for example, take teledermatology. Video technologies can provide high levels of accuracy in diagnostic imaging, while in other situations, the medical boards might want the doctor to see the patient in person, and they could use standard of care as an enforcement hammer, depending on the situation, even if the statute is liberal. I mention this because this happened recently in one case involving a physician in California named Dr. Holmes, who was prescribing for ED based on an internet questionnaire. Now, to the extent the prescription involves a controlled substance, the federal Ryan-Haight Act requires, with few exceptions, that the physician does conduct an in-person evaluation of the patient before issuing the prescription. At this point, many law firms have jumped into the telemedicine legal market, but the reality is that there's no magic bullet, there's no secret survey, there's no single source I believe you'll find on the internet that's going to solve all of the pain points around telemedicine It's about researching state law, coming up with a good model, and giving a really fine legal analysis and recommendation. Thanks for watching this video. If you have questions, contact us at cohenhealthcarelaw.com/contact to book an appointment or send us a message. We look forward to speaking with you soon.